Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. If you want to move and work in the US, this video summarizes your non-immigrant visa options. For most visas, you'll need a company in the US willing to offer you a job before you apply for the visa, but there are some options mentioned in this video, where this is not needed. 1. The H1B Visa. The H1B visa is a non-immigrant visa that allows a U.S. company to hire workers in specialty occupations. H1B visas are available to nationals of any country, but there are only 85,000 new H1B visas available each year. This is the limitation unless you'll work for a CAP-exempt employer. This means that each year around March, USCIS runs an H1B lottery in which it randomly selects 85,000 H1B registrations. 65,000 regular registrations, and 20,000 spots are reserved for people who hold a U.S. master's degree. You will need a U.S. company to file the H-1B registration on your behalf. This is usually done in February or March each year. You cannot submit the registration on your own behalf. The H-1B requirements are as follows. 1. You generally need a U.S. bachelor's degree or foreign equivalent, have an unrestricted license, or have progressively responsible experience in the specialty occupation. 2. The job in the U.S. is a specialty occupation. 3. You have a job offer from a U.S. employer and the employer is willing to sponsor you for the visa. The U.S. employer will need to pay the H-1B fees. And 4. The employer needs to pay you a prevailing wage. This is the standard wage for your particular profession, in a particular geographic area. The H-1B visa is a dual intent visa, meaning that you can have a green card petition pending while you are in the U.S. on an H-1B visa. You can even renew your H-1B visa while the green card petition is pending. The H-1B visa can also be granted for up to 6 years, and can be granted for 3 years at a time. 2. The E3 visa. The E3 visa is a non-immigrant visa available to Australian nationals only. The requirements are very similar to the H-1B visa requirements, but the application process is much simpler, especially if you are applying for an E3 visa at a U.S. consulate. You will need a U.S. company to sponsor you for the E3 visa, and you need a job offer. You cannot come to the U.S. on an E3 visa to look for a job. The E3 visa is not a dual intent visa, and can be renewed indefinitely. 3. The TN visa. The TN visa is a non-immigrant work visa available to Canadian and Mexican nationals. You only need to hold a passport from these countries, you don't need to be born there. To qualify for a TN visa, you must 1. Have an offer from a U.S. company. 2. Your profession must be listed on the United States-Mexico-Canada Agreement, or USMAC list. Many professions are listed such as a lawyer, architect, engineer, or pharmacist. And 3. You must meet the education or relevant experience requirements, as specified for each occupation on the USMAC list. One great advantage of the TN visa is that if you are a Canadian, you don't need to schedule an interview appointment at a U.S. consulate, and you can simply apply for TN status at a port of entry. The TN visa is not a dual intent visa. A big advantage of the TN visa is that there is no limit as to how many times you can renew. As long as you qualify and keep meeting non-immigrant intent, the visa can be renewed. 4. The O1 visa. The O1 visas are for individuals with extraordinary ability in the field of science, education, business, athletics, or arts, or for people who have extraordinary achievements in motion pictures or the television industry. Generally, the O1 visas are for people who are in the very top of their profession. You will need a U.S. company to sponsor you for this visa. You can also set up a U.S. entity, and this entity can sponsor you for an O1 visa. You can be granted the O1 visa initially for 3 years, and then renew it either for 1 or 3 years. The O1 visa is also a dual intent visa. 5. The L1 visa. The L1 visa permits a U.S. employer to transfer an employee with specialized knowledge relating to the organization's interests, or a manager or executive from one of its affiliated foreign offices to one of its offices in the United States. Therefore, this visa is reserved for people who worked for a certain company abroad, and who are now being transferred to the U.S. To qualify for L1 classification, the employer must 1. Have a qualifying relationship with a foreign company. For example, subsidiary, branch, etc. 2. Currently be, or will be, doing business as an employer in the U.S. and in at least one other country directly for the duration of the beneficiary's stay in the United States as an L1. 3. The employee must have been working for the qualifying organization abroad for one continuous year, within the 3 years immediately preceding his or her admission to the United States. And 4. The employee is seeking to enter the U.S. to provide services in an executive or managerial capacity, or specialized knowledge capacity for a branch of the same employer, or one of its qualifying organizations. You can be granted an L1A manager or executive visa for up to 7 years, and an L1B specialized employee visa for up to 5 years. The L1 visa is a dual intent visa. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.